Hi, and welcome to Chapter 12 in your commercial law curriculum. Today marks an important transition in our study of contract. Up until this point, we've been dealing with common law applications and analysis of the law of contracts. And today we're going to shift and start talking about contracts under the Uniform Commercial Code. And as the common law of contracts lagged behind the needs of the commercial world, statutes started to be passed to regulate commercial transactions. These general statutes, adopted by some states, cured the problem for a while, but the need arose for a uniform system of laws to govern commercial transactions across the country. Therefore, the National Conference of Commissioners on Uniform State Laws began developing what we know today as the Uniform Commercial Code. It's one of the most successful uniform codes ever derived, and it's been adopted by nearly all states except. And one of the main reasons that the Uniform Commercial Code became important is that businesses don't like uncertainty. And the laws of one state, let's say North Carolina, may not have matched the laws in California. And so when two companies from those two states got together and tried to form a contract, they weren't exactly sure which rules applied. Now that we have the Uniform Commercial Code, merchants in both North Carolina, California, and indeed across the country can be sure of the rules that apply to the construct of a contract between the two businesses, thus eliminating a lot of the uncertainty that was there before. The Uniform Commercial Code is made up of 11 articles. There's a good exhibit, Exhibit 12-1 in your book, that shows you or gives you a list of the different articles of the Uniform Commercial Code. We're going to deal mainly with Article 2, which deals with sales. So let's start talking about what the Uniform Commercial Code covers. So I think the first thing that's important to understand is the difference between the application of the common law and the Uniform Commercial Code, and the scope of Article 2. If we're dealing with a contract that is between private individuals for services, Article 2 is probably not going to apply. However, if we have a merchant involved and we have the sale of goods involved, then Article 2 is probably going to apply. Both the terms sale and goods are defined in Article 2. Sale is defined as the passing of title for a price, and goods are things that are movable at the time of the identification to the contract. And Article 2 applies to the sale of goods, especially between merchants. So the obvious question is, how do we decide if we have a hybrid contract that involves both the purchase of goods and a service? For instance, in your book, there's an example that deals with the purchase of carpet and the installation of that same carpet. And essentially what you're going to look for is the predominant factor or the primary purpose. That's a doctrine that we use to determine which law applies. If the predominant purpose of the contract was the purchase of the carpet, then the UCC is going to apply. If the predominant purpose is the installation, then common law would apply. You think about hiring somebody to paint your house. If you hire them to paint your house, that's a service. If you go somewhere to buy the paint, then you're purchasing a good. It's a sale of goods, so to speak. If a contract involves the contractor actually purchasing the paint for you and painting the house, then you have to look at which is more important. Probably the labor that goes into it is more expensive than the paint itself, and therefore would be the predominant purpose. So the next question is, when we determine that the UCC applies, so the UCC Article 2 applies, what's the difference? And the difference is that most of the rules that we've learned under the common law are relaxed, and they are to promote business. They are to promote the commercial business world and accommodating the realities of the speed at which business moves. So let's look at offer and acceptance first. Now, under the common law, we learned that in order for us to have a contract, we must have an offer and acceptance, and there's some pretty strict rules that go along with that. As we're going to see as we go through our analysis of Article 2 of the UCC, offer and acceptance and the rules that go along with it are greatly relaxed, and they can be, the offer and acceptance can be any manner sufficient to show an agreement. The court's going to err on the side of finding an agreement if that's what the parties want. Even some of the important terms can be left open. You may not know exactly when the contract is actually made. We'll talk a little bit about firm offers remaining open without consideration, as is required under common law. and some different ways of showing acceptance, including through the acceptance of the goods that have been shipped. Let's take a look at the mirror image rule and the way that the UCC modifies it. If you recall, under common law, an offer and the acceptance must be exactly the same. If there's any deviation from the offer, it's considered a counter offer. The common law is very strict in its interpretation of the mirror image rule and doesn't allow any change in terms during the offer and acceptance process. The UCC treats this in a very different way. It actually allows some changes to the offer during the acceptance process and doesn't constitute a counteroffer. They constitute additional terms to be added to the contract that can be accepted or can be rejected. By way of example, let's say that I am a widget seller and I call a widget manufacturer and I say, I'd like to purchase 1,000 widgets from you and I'd like you to ship them by train. And on the other end, the widget manufacturer says, I accept your offer, I'd like to sell you the 1,000 widgets, but I want to ship them by truck. At that point, under the UCC, we have a contract for the sale of widgets. And the only item left to be determined is the manner of shipment. I can either accept that the widgets be shipped by truck, or I can reject that portion of the contract and leave it open to where we have to figure that part out. So the additional term is construed as a proposal for addition to the contract, not as under the common law would be a counter offer. So we have a contract, we have a term that needs to be worked out at that point. So we have this missing or open term. How are we going to figure out what needs to go in that spot? Well, we can do a couple of different things. The party's behavior in the past can show the existence of a contract under the UCC. So if in the past it has always been shipped by train, then the court may say it has to be shipped by train. That's the way you've always done it. If we've just completely left one of these terms out, and we haven't even talked about it, the UCC has some other mechanisms it can use to try to figure it out. What is industry standard? In other words, how do the widgets usually get shipped? Is it by truck or train, or is it by airplane or something else? Whatever the industry standard is, that'd be the term that was filled in. So you can look at the way the parties have dealt with each other in the past. You can look at what industry standard is, or anything else that'll help the court to get to fill in that term. One of the main premises of the UCC is the duty of good faith, and the duty of good faith is supposed to be implicit in every contract. In other words, merchants and individual offerors and offerees are supposed to act in good faith with regards to each other. It's a meticulous and important standard and is the basis of the UCC, and this moving at the speed of business requires that kind of trust. It requires honesty in fact. And it also requires that merchants act in a commercially reasonable manner. If we're going to allow these contracts to be formed so relatively easy to the common law, we have to expect that merchants are going to act in a commercially reasonable manner. And if they don't, then the court has a way to sort of a backdoor out of enforcing a contract. So honesty in fact and commercial reasonableness are both important yardsticks when we're trying to measure whether or not we have an agreement between the parties that is enforceable. So along those same lines is the doctrine of unconscionability. As we've discussed, for a contract to be formed and performed, it has to have an element of good faith. One area that is fraught with bad faith brought about the doctrine of unconscionability. And from previous chapters, you should remember that contracts that are too one-sided or too harsh can be considered unconscionable as a matter of law. As with the common law, the UCC provides a specific out for contracts that are unconscionable. The statute of frauds is also something that Article 2 and the UCC recognize. Just as with the common law, under certain circumstances, a contract has to be in writing to be enforceable. But again, as we've seen with other terms, the writing requirements are somewhat relaxed. Basically what we need is something that is signed in writing by the parties. It doesn't have to include price or quantity necessarily, but if it is for sale of goods over $500, we're going to require a writing in order for it to be enforceable under the UCC. Again, with the parole evidence rule, we see some changes from the common law in that the rule allows for extrinsic evidence to explain, clarify, or supplement the party's understanding of the contract. So if you have a written contract or an oral contract and some of the terms are left out, the court needs a way to fill in those blanks, so to speak. There's a couple of different ways they can do that, some of which we've talked about. The first would be course of dealing, the parties' prior conduct towards one another, including previous transactions they had. So if there's, again, when we talked about shipment, if the parties have normally shipped those widgets by train, then and they left out that term in the written contract, then the court is going to say, based on the course of your previous dealings, we're going to say that it was intended to be shipped by train. The other two are usage of trade and course of performance. Usage of trade is the commonly accepted industry standard and practice. Course of performance is the party's past performance or acquiescence, their habits under a contract that have been involved with each other on repeated occasions. I just generally want to note that common in today's commercial world is the lease of equipment or the lease of goods, and this was something that Article 2 didn't adequately cover. So Article 2A of the Uniform Commercial Code now covers leases, which are transfers of the right to possession and use of the goods for a term in return for consideration. It's not the sale of goods, it's the lease of goods. So if you're dealing with a lease agreement, make sure you're looking at 2A and not Article 2. So in summary, the UCC is a statute that regulates commercial transaction. It's been adopted in some form in all 50 states and provides uniformity for parties entering into commercial transactions on a nationwide basis. It's developed into 11 articles, and we mainly deal with Article 2 in this class, Article 2 of the Uniform Commercial Code. The sale, a sale transfers title from seller to buyer for a price. And Article 2 is specifically talking about the sale of goods between merchants and non-merchants. Sales between merchants are subject to higher standards of good faith and reasonableness than for non-merchants. And the sale between parties must be a sale of goods in order for Article 2 to cover. Keep in mind that under Article 2, the rules of contract formation in some cases have been greatly relaxed. The mirror image rule is a specific example. It's been completely modified by the UCC. The UCC does have a statute of frauds and a parole evidence rule provision, but again, both of these rules have been greatly relaxed. So it's important to categorize your contract. Is it covered and analyzed under the common law, or is it covered and analyzed under the UCC? Because the rules of interpretation, the rules of formation are going to be greatly different depending on which form of analysis you're using. Well, that's all we have for today. As always, if you have any questions, don't hesitate to contact me, and I hope you have a great rest of your week.